by Perrin GrauerStarMetro VancouverWed, Sept. 12-2018 VANCOUVER, the special prosecutor appointed to review the conduct of 4 RCMP officers involved in the 2007 tasering death of Robert Dziekanski at the Vancouver International Airport has officially concluded his work. In a statement, Special Prosecutor Richard Peck explains why the officers were ultimately charged with perjury, rather than charges directly related to Dziekanski's death, such as manslaughter, assault or assault with a weapon. Former RCMP Constable Kwesi Millington, who abandoned his appeal from his sentence in July, leaves court in 2014 during his perjury trial in Vancouver. Special Prosecutor Richard Peck, appointed to look into the conduct of Millington and 3 other RCMP officers following the 2007 tasering death of Robert Dziekanski at the Vancouver International Airport, has issued his final report. Daryl Dyke, the Canadian Press, both death-related offences, writes Peck, and offences related to the conduct of the 4 officers during the subsequent investigation of the incident, whether the officers committed obstruction of justice or breach of trust in providing notes and statements to RCMP investigators, were unlikely to result in conviction. Likelihood of conviction is one part of a standard set by the BC Prosecution Service (BCPS) to determine whether a prosecution should proceed. In October 2017, Robert Dziekanski died after being struck multiple times by an RCMP taser in the Vancouver airport. Dziekanski, who had traveled to Vancouver to visit his mother, had become visibly agitated after spending nearly 9 confusing hours in the airport, prompting several parties to call Richmond RCMP. In 2013, the BC Coroner's Service ruled Dziekanski's death a homicide, a term which, in a coroner's report, means the death was caused by another person, but which does not imply blame. The announcement of Peck's conclusion of involvement, made Tuesday by the BCPS, comes following the end of court proceedings in July marked by former RCMP Constable Kwesi Millington's abandonment of appeal from his sentence of 30 months less a day for perjury related to his testimony during the public inquiry into Dziekanski's death. Peck was appointed in 2010 to reassess the earlier decision by the BCPS not to prosecute any of the officers involved in Dziekanski's death. Peck was also asked to investigate the conduct of those officers in connection with the incident. He writes that for charges outside of perjury, evidence either did not support the elements of a particular offense, such as manslaughter or obstruction of justice, or, where it did support those elements, did not present a case sufficiently strong to meet the BCPS standard for approval. Peck adds that this is partly due to the fact that all 4 officers had testified in 2009 at the public inquiry into Dziekanski's death. Under Canadian law, a person who is compelled by subpoena to testify may not have that testimony used against them in any subsequent criminal trial, writes Peck. In short, the fact that the 4 officers were compelled to testify at the inquiry presented a significant obstacle to the prosecution. Peck continues. To proceed with a prosecution of these offences, the Crown would be, to use a well-known expression, trying to put the genie back in the bottle. All 4 officers were tried separately between 2013 and 2015. Former Corporal Benjamin Robinson was convicted of perjury in 2015 and sentenced to 24 months less a day, while Const. Jerry Rundle and Const. Bill Bentley were ultimately acquitted of the same charge. With files from Canadian Press. Perrin Grauer is a Vancouver-based reporter covering Canada's cannabis economy. Follow him on Twitter, Perrin Grauer. Top stories, delivered to your inbox. New NEWSLETTERHEADLINESSIGN up.